Hello, and thank you for joining us for the next session of the Destination IP Virtual Summit. In this session, Garth, Vivier, and Marais will discuss patent strategy for startups. A recording of the webinar and the slides will be made available to all registrants. Feel free to enter any questions using the Q&A feature in the Zoom menu. Also, feel free to follow us on LinkedIn to see news about other upcoming webinars. Our speakers today will be Garth Vivier and Marais. Garth Vivier is a registered patent attorney and principal of Schwegman, Lundberg, and Wissner. Garth is included in Intellectual Asset Magazine's IAM 1000 listing of distinguished patent attorneys. His focus for 28 years has been on the procurement of high-value patents for both multinational corporations and startups. On a regular basis, Garth assists startups in Silicon Valley and abroad to develop IP strategies tailored to the tight budgets most startups faced. A patent strategy should be closely aligned with business objectives, and he has gained practical insight into how to accomplish this. Marais is a registered patent attorney and principal of Schwegman, Lundberg, and Wissner. He has been included in Intellectual Asset Magazine's IAM 1000 listing of distinguished patent attorneys and in the IAM Strategy 300 listing of the world's 300 leading IP strategists, as well as in IAM Global Leaders. Is passionate about architecting, building, and managing patent portfolios with his clients. Having had the good fortune to work closely with a number of Silicon Valley's most prominent software and companies since their early days, he brings an in-the-trenches perspective to portfolio strategy and growth. And with that, I'll hand things over to Garth and Andre.
Great, Michelle. Thanks for that introduction, and welcome everyone. So Garth and I were thinking just about how to format today, and I think the way we're going to do it is just kind of a fireside chat between the two of us, trying to just answer some of the more common questions that we've received from startups over the years, and perhaps some kind of just as practical insights into patent strategies for a startup. I will just say out the bat that we're going to be focusing on patents, and really not broadly IP strategy, but more kind of patent strategy. So we'll maybe touch a little bit on trademarks and designs, copyrights, and etc., but really focus on patent strategy. The word patent strategy tends to mean a lot of different things to different people, and if you Google it, you'll find a wide variety of opinions and what people regard as patent strategy. But I think we're going to really look at it by answering kind of three questions, or three questions over here. The first one being constraints. What really define the constraints that apply when defining a patent strategy, and then really answering very importantly the question why. Why if we're a startup, why are we even filing patents? Why do we have a patent strategy? And then we're going to also dive into how and what, the how and what really to how to implement a patent strategy. At the outset, I would just point out that patent strategies can be very formal and written and documented, but can also be somewhat informal, and can also be dependent on the size of the corporation or the size of the other client, will vary widely. But one of the key characteristics of a patent strategy is this dynamic, because it really needs to be aligned with your business strategy, and the world and business environments are very dynamic, so your patent strategy needs to be dynamic. We're also going to welcome questions during the presentation, so if you have any, feel free to type them in the web chat, and Garth and I will attempt to answer those as we work through things. Anyway, so Michelle, maybe we can move on to the next slide, and I'd like to maybe pose this question to Garth: is like, really, what are the what are the biggest constraints that you see for startups, with respect to pursuing patents, straight out of the gate? Garth?
Yeah, I think almost the first question we ever get asked is how much, the budget constraints. And quite frankly, large corporations, startups, all have budget constraints. The advantage a large corporation has is they can just move money in their patent budget from one group of assets or one technology area to another. Startups don't have this luxury, and typically, finding money to pay fairly large upfront costs in patents is very challenging. So, and even after a patent's issued, if the startup pursues foreign filing, those costs can escalate and become very, significant. So the goal really when we do a patent strategy is to try and effectively get the most cost-effective protection we can for a startup. And that typically involves different techniques we have, but the strategy is, as Andre pointed out, dynamic, because the dollars do change. A good round of funding maybe brings out more funding, which means more dollars available for the patent strategy. And so then it will change. So by and large, I'd say dollars. Another issue that does come up is how much time is it going to take? And what's the drain going to be on our engineering resources? In a small startup where the CTO may wear multiple hats, and likewise the CEO, they don't have a lot of time to spend reviewing documents, etc. So that can be a challenge. But with the right meetings, explaining what we need to do and getting some upfront documents from the startup, we can definitely reduce the time constraint and the pain and suffering, so to speak, on the engineers and the startup itself. Andre, I don't know if you have anything to add to that.
No, I mean, I think Garth, you're going to touch on this a little later, but I think the challenge for startups is often that they're doing some of their most innovative work and most groundbreaking research and development early on, when cash and time are probably at a minimum as well. So yeah, balancing that's always a challenge.
And to Andre's point, we have some techniques that can alleviate the problem. So maybe then I'll ask you the question, Andre, that I get frequently is startups ask, why should I even file patent applications? Why do I even need a patent program?
Yeah, no, and as a very common question we get. Michelle, maybe you can advance to the next slide here, and yeah. So what we got on this slide is just a number of considerations or reasons why a startup should at least consider a patent program. Doesn't mean you have to do it, but these are just some reasons you may want to consider. The chart over here also indicates a percentage. So those percentages will vary from startup to startup, and also over time, as the business progresses. But I'll maybe just start with dealing with the first two there, which is really the first one is freedom, freedom to operate. And what we're really saying there is that by building up a patent portfolio of your own, that can buy you freedom to operate in the marketplace. In that, if people out there know that you have a patent, a patent portfolio, it might deter them from suing you for patent infringement if they know you can hit back. And also these patents give you something to trade with during cross-license negotiations with another company that you might want to cross-license with. Once technology is mature, we actually see this a lot where large companies will often sign a 5-year cross-license and come together and every 5 years renegotiate that and kind of look at who's got what patents and all of that. And so very often this is something that may be a little further down the road, but you really want to be doing the groundwork early on, and to ensure your freedom to operate as as you grow. The second reason there might be industry collaboration. If you're going to be entering into joint ventures with third-party entities, really having patents filed on what's yours before you enter that joint venture can really give you confidence, and also make sure that that joint venture, or reduce the likelihood that there's going to be any squabbles or disagreements later about who invented what, and it brings it brings you something to the gives you something to bring to the table for a JV. Likewise with standards bodies, a patent portfolio can really buy you a seat at the table at those type of bodies, and if you've got something to contribute over there, you can be recognized as a player. So we see those being valuable assets down the road for those those purposes over there. Garth, did you maybe want to talk about the next three, like valuation, defensive, offensive reasons?
Yeah, sure. I think, as we said, the strategy is dynamic. The need for patents changes. But one of the areas I find where patents are of great value to startups is to secure funding. Both Andre and I work with a lot of multinational law firms in the Bay Area. We don't do transactional work, litigation, etc. We do, patent procurement, so to speak, predominantly. And so we have very good relationships with those firms, and they send a fairly large amount of startups our way. And so it's definitely securing a portfolio of some sort, and that's budget based again, definitely helps with evaluation. I mean, we're aware of that. The VCs ask, and look into what patent protection have you received, or what applications do you have on file. So I think securing funding, there's, in my mind at least, absolutely no doubt that a good patent portfolio and strategy, and it doesn't have to be large. We'll deal with some ways of building portfolios later, but is of great value. Some of the startups we meet with, have a short exit strategy. So, if the exit strategy may even be shorter than the time period it takes for the first application to be examined by the patent office. In that case, they're looking to, posture a patent portfolio to look attractive for an acquisition, for example. So it really does vary, but I would say without doubt, patents do add value in terms of trying to obtain funding, and quite frankly in exits as well, which we'll get to. Another option, advantage would be, defensive. And Andre alluded to it earlier, tying up the technology developed by employees to preclude them from leaving and starting similar tech industry or tech startup somewhere else using similar technology. I'm not saying steal trade secrets at all, but they have the know-how, and they do, in fact, they may have contributed to a particular inventive feature that hasn't been patented. And if a startup files a patent application, they have a possibility of getting a monopoly for the technology. If they don't file, they're saying to their competitors, they're free to leave. Recently had a situation where a startup in the Bay Area, two founders ended up disagreeing on certain issues, left the company. Fortunately, there were agreements dealing with assignments of IP rights. Patent applications were filed, and it turned out to be very, very beneficial to those remaining in the startup. There's also as a company tends to mature, there are opportunities to license the technology. That typically occurs later in the life cycle of, so to speak, of a corporation. The startups initially probably don't have the time to pursue licensing options, but the fact that it provides an option and a seat at the table, as Andre mentioned, later on to secure some revenue from licensing. It's also important to have a patent portfolio to maintain a market position. to preclude competitors copying your technology, and you're helpless because you haven't filed a patent application. So I think there are definite benefits of, in terms of valuation, defensive and offensive. And, with that, maybe I'll ask you, Andre, what has your experience been from a recognition point of view and the advantages, accounting advantages with tax credits, etc.?
Sure. Yeah, so I mean, we do see a lot of clients using patents for recognition, and when we talk about recognition there, that could be recognition of the company or the startup as being innovative, just the fact that you might have filed X number of patent applications may be used by the marketing department or just in the company's general dealings to establish and back up claims that they're an innovative company, but then also as a motivational tool within the company, where you want to recognize your geniuses and your inventors, and obviously filing patents is a great way for employee recognition as well. Moving on to the R&D tax credit. We actually had a talk on this at last year's summit, where you can actually use your patent applications to really support the R&D tax credit applications, and this can really be a valuable piece of evidence in securing that tax credit. So we see a number of companies doing that, and actually partner with a few financial advisors to help our clients on that front. Yeah, so there may be some other reasons as well, but these are typically what we ask clients to look at, and also to advise us why are they pursuing patent protection, because if they're pursuing it for evaluation, we might do something a little differently than if it is purely from a defensive perspective. So this answering the question why really and providing that information to your patent attorney really allows your patent attorney to it's an important input into crafting a patent strategy that's going to give you maximum value and obtain your objectives. But Garth, I mean, I don't know, over the years of practicing, it might be useful just to share some stories of startups that we've worked with that have actually achieved some of these whys or had some successes if we look at these motivations. So any examples you could kind of share with everyone?
Yeah, and in fact, the example I can think of sort of ties in with our valuation bullet point there on the slide. We did work for a silicon photonics startup and grew the portfolio over the years to, initially started off fairly small, but ended up being, if memory serves, like 40, 50 assets, combination of patent applications, a few issued patents, and some carefully selected foreign countries, choosing, because of the expense of foreign filing, very carefully selecting patent applications to file in some of the major jurisdictions where there would be competitors. And this particular startup was acquired by a multinational for $165 million. And it's my understanding that the patents were one of the driving forces in the acquisition. They had started working on a technology early, filed patent applications really early, and were ahead of the curve. I've had another startup in a different way that was trying to secure some government contracts, and there were some competitive bids, but we had filed a few patent applications for our particular startup that we were working with, and they ended up getting the tender. Now, whether the patents made a difference or applications made a difference, I don't know, but I would guess if you have two equal tenders in front of you and one has patent applications pending, I would assume that you would lean towards the one with the patent applications. So those are just two examples. I have worked for done some patent work for another company on the other end that were sold for $1 billion, and they had 2 patents. So there is a different side to it as well. but that I would say is the exception. I've seen more benefits of filing the patent applications. I mean, Andre, you've got a few examples as well, I'm sure, that you could share.
Yeah, no, I have. Oh, Garth, before that, we just got a question from the audience here. What is the significance? The question is, what are the significance of the percentages in the slide that's up now? And those are just to indicate. Those are just different companies may value those differently. So this is just for an example. Company may value freedom to operate at 90%, but have no offensive license or no licensing plans. So the licensing is at 10%, whereas freedom to operate is a 90% Y. But again, if you're a startup and you were mainly developing technology with a view to licensing, and you were really not going to be a manufacturing or producing entity, but more of a licensing entity, clearly the quote offensive / licensing would go to 100% or something like that. So just to answer that question. But yeah, Garth, I think you made a great point there. Is that I think having a patent portfolio early on and is really, for a lot of companies, not going to really determine whether you're successful or not, but can definitely help. We've seen some companies be very successful without having filed patent applications early on. But my view is there that they can be helpful very early on, particularly if you're fundraising, but a lot of the value actually kind of accrues later once you maybe get into you're a more mature company. Particularly if you're very innovative, you might be running out ahead, but there are a lot of fast followers out there, and as soon as someone sees someone being very successful, the imitators are going to come out of the woodwork very quickly, and it may take 2 or 3 years for a substantial competitor to emerge if you're really groundbreaking. So two examples of companies that Tesla is an example. They started off with a strong patent program, and then Elon Musk indicated that he was going to be licensing it, and effectively they really shut their patent program down for all intents and purposes. I mean, they're still filing patents, but not a lot. And again, Tesla hugely successful. But what we're seeing now, and I don't know if anyone's been watching the news, but they've just accused Rivian of stealing trade secrets in one lawsuit, and actually have another trade secret lawsuit going on against a Chinese electric motor startup. And again, are having to rely on trade secrets. That's a good option, but I do wonder whether Elon Musk had wished that he had maybe filed a few more patent applications, because it would be able to it might have been useful for them to rely on trade secret and patent protection for different technologies there. So, but again, I mean, an example of a company that's done well. Another company that doesn't have a big patent portfolio is Zoom. We're on their technology on their platform right now. I think they've got it. When last I looked, a total of 6 issued patents, which is not a lot. Again, a tremendously successful company, but there are a number of other companies, biting at their heels and wanting to get onto this. And I just do wonder whether it's going to be a matter of time whether they wish, Zoom had. And they may have some patent applications that we're not aware of, but would they wish they'd file more patents later? Who knows? But 2 companies I've been involved with. One startup which had VC funding for 45 million based on the founder's track record, and they took a very aggressive approach on patents when they approached us. They basically said, "Here's 5 million of that. We want to file patents on every single thing we can." Even before product release, which was very unusual for a startup. They were in that unique situation of having a lot of money even before their product had been released. And we filed a very extensive patent portfolio for them. And in that case, unfortunately, the business actually failed. But they had this patent portfolio, which ended up being, at the end of the day, they sold. There's an acqui-hire of the engineers, and the company was sold. But they actually managed to carve out the patent portfolio and sold that for much more than the actual company itself and the acqui-hire was for. So there was a case of they actually managed to recover a lot of value from their technology as a result of having filed some patents.
There's also some organizations in the Bay Area. One that comes to mind, I think, is Sherwood Partners. They specialize in actually buying patent portfolios out of distressed companies and obviously reselling them and making money out of it.
And again, I think that's, getting back to the valuation reasoning, is that, a lot of the VCs, I mean, they're from a risk management point of view, them having working with a startup which is going to file, a lot of patents, gives them, at least some assurances that if things do go south, they've got some assets over there that they can sell and, hopefully recover some of their investment. But of course, the hope is that the startup is going to be hugely successful, and the patents will be helpful, and for some of the other reasons on that slide. Okay, great. I think maybe we can kind of move on to the next slide now, which Michelle, if you could kind of just advance that. So I think here we really wanted to kind of answer the question, how does the startup engage with their patent attorney? What does the beginning of the relationship look like? And how do you even get a patent program kind of off the ground? We've got the bullets on the left over there, and I think the first one we like to point out is, one thing to kind of start out up front is maybe to define a patent strategy. As I mentioned before, patent strategy can be different things to different people, but we do think it is good to have some at least game plan about where you want to go, and where you want to take things, and kind of really formalize that thinking a little bit, and then have a living document that you can go back to, which informs decisions and is kind of a reference point. But if it's a very early stage startup, and we've got the startup has one product, and it may be premature to define a patent strategy. It might just be, hey, let's get a patent application filed, or let's get the patent process started to cover what we have over here, and we'll get into the more sophisticated patent strategy later. But if you look at the circle on the right, when we kind of define patent strategy, I think the two of the action items are target and evangelize. So really, if you're a more mature company, and you got a bunch of potential inventors, and you've got a few tech products and a few technologies you're active in, you may want to really figure out which people are going to be targeted as contributors to the patent program. What are your key technologies? What are your key products? And this is more information to provide to the patent attorney, so that the patent attorney can keep all this in mind as he or she moves forward with your patent portfolio. So a big part of patent strategy definition is really just kind of collecting information regarding the business, the competitive landscape, and what the business hopes to achieve, and making sure that your patent attorney is aware of that and can do what he or she needs to do, keeping that in mind. The second thing is there really is evangelization. Within an organization, particularly if you're getting up to 50 to 100 people, so you're a more mature startup, you might want to evangelize your patent program internally, and that's marketing it to your potential inventors, educating your inventors as to what the process involves, incentivizing your inventors through various rewards, and also providing some recognition for those inventors. But Garth, maybe let's like back up to perhaps an earlier stage startup that evangelization and targeting may be a little premature for them, and really kind of look at the harvesting harvesting patent candidates, which I think is the next bullet we have there. So any thoughts on kind of best practices there?
Yeah, I think an initial meeting, which normally would take about 2 hours with the patent attorney, for the client, the startup, to to explain to us the high-level technology platform. We need to see the big picture. And once we've got there, and it, in the old days it was more like whiteboarding. Nowadays will probably be more, Zoom meeting, maybe perhaps whiteboard as well. But sketching out drawings and whiteboarding the broader platform. And then we would typically sort of start drilling in on the various nodes or components of the system. What's really important though when meeting the startups is always to keep in mind that the patent strategy should be aligned with the business strategy. There may be some really cool inventions that aren't really of high business value. So you really want to focus on where the most where you're going to get the most value from a business perspective. And once you understand the broader technology, then what I see is like an innovation curve with startups. I see the first couple of months, typically 6 months, maybe up to a year, a tremendous amount of innovation takes place. And during this time, the startup is fairly sure of what product they want to release. They've worked out how they're going to do it. They may not have built it yet, but they definitely have a fairly good idea how they intend to build it. And so getting a brainstorm together with all the relevant people in the room to go through the technology, the platform, identify important aspects of the technology, and then starting to, what I think is really, really important is document it. And when I say document, I don't mean write extensive reams of paper or multiple pages in Word. Get a spreadsheet together. Identify the inventions. And anyone who wants an example of the spreadsheet can contact us and we'll send you an example. And in the spreadsheet, who the inventors were, has it been disclosed publicly? So at least you've got a bit of a roadmap of what's being done. And it's important actually to keep that spreadsheet up to date. Now, obviously, the more sophisticated and clients that have grown have case management systems, etc. But a spreadsheet's a good way to start. And in trying to identify inventions, the patents are really for technical solutions to technical problems. So asking the engineers or the CTO, what technical difficulties have you encountered? And then, what was the technical solution to that? And that would, as a way of identifying inventions. What's also a way of identifying valuable subject matter is to say, what technically do you want to preclude your competitors from doing? There's some parts of your system you may not be too bothered if they copy, but there are certain core ideas that you definitely don't want them to do. So that allows us to start harvesting ideas. And it's also important to think broadly, not just narrowly in these meetings, but to go through the product. If there's a solution to a particular technical problem, ask the question, could this solution apply in other industries or other technologies as well, so that you can get broad protection. There are obviously ways of keeping an ongoing record, but then I think one of the issues, once you have a spreadsheet populated with ideas, is to look at the value. And Andre will, maybe I'll ask you, you can share your thoughts on how you would value the inventions. But the idea has also come up, and we frequently get asked, well, should I just keep it as a trade secret? Well, the problem I often have, particularly in the software space, is how long can you really keep something for a trade secret nowadays? You have an employee that leaves, can it be reverse engineered? And we've got some techniques for actually hedging your bets against, keeping your options open so that you can actually pursue either a trade secret or patent protection in due course. There's a technique we use. But another, post the meeting is this collection of information, drawings, PowerPoints, etc., that will help the attorney file the application. In some cases, there may be 1 or 2 pending applications already that can be reviewed and mined for continuation applications. In these meetings, I think there are a number of time periods to look into very critically, the US has a grace period of 12 months in which you can still file a patent application and get valid patent protection. Most countries throughout the world require absolute novelty, and that means no publicly disclosure, public release, etc., of a product or an invention prior to filing the application. So typically I would ask the startups, what in the last 12 months have you done that you would like to get patent protection for? Because those items the clock's ticking for. Then typically the next period we would look at is what in the short term, maybe in the next couple of months, 6 months, are you planning on releasing? Sometimes if you're dealing with universities, there would be publications upcoming because we would ideally want those applications filed prior to public disclosure. But I think once the information has been gathered, this dynamic spreadsheet has been completed, then the next step is an evaluation step. And perhaps, Andre, you can address, how does a startup decide which applications to consider for filing once they've built up a spreadsheet or an inventory of potential filings?
Yeah, no, absolutely. Thanks, Garth. Yeah, so I mean, we recently, worked with a startup where we did, the quote harvesting or discovery meeting that Garth was referencing, which would be the harvest section over there, and really populated this spreadsheet with, maybe it was 80 ideas. And I think that the thing during those meetings is really to communicate to the attendees or the participants in that meeting that there is no bad idea. We just throw everything in there. Even if you think the patentability may be marginal, let's at least get it considered. So for this startup, we ended up with, let's say, like 80 ideas, and then the question is, okay, well, what do we patent here? And that's where we kind of get into a ranking and rating. So our spreadsheet actually also has a bunch of columns where you can attach to each idea, in these various criteria, a ranking value. And broadly, we break these up into legal criteria and business criteria. But then, as shown on the slide there as well, timing and costs are also two things that are going to determine what you proceed on, not just the kind of ranking. But the legal criteria are really look at how likely are we to get a patent on this? How new is it? But even then, we always do clearly communicate to inventors that for something to be, to get over the newness or novelty hurdle in patents, isn't really that isn't that much of a high hurdle. It just has to be, a little new. The other requirement, obviousness, becomes a little more significant as the novelty becomes a little more questionable. But I think it's worthwhile communicating, at least for this harvest session. Let's just throw anything into the list. And then we go through and kind of give it an initial assessment as to how new we think it is. Very often they will also do some prior art searching, because the inventors might tell us, hey, he or she, the inventor might say, thinks this is very new, and we do a prior art search, and it turns out there's close prior art, and then we adjust the ranking downwards. On the other hand, the inventors may indicate, we don't think this is new, but we haven't seen it. And we do a prior art search, and there's nothing, and we might then bump it up. The legal criteria may be adjusted based on the results of the prior art search. Business criteria, really then go into, is this covering a technology or a product that is a key revenue generator for us, or even more interestingly, is this this feature or this product, if our competitors were to implement it, would it be a major revenue generator or contributor or cost saver for them? Because we might find something that's very legally patentable, it's very clever and new, but it relates to a feature that is not a big differentiator and not a big value driver for the company. Other criteria, there may be detectability. If our competitors were to implement this feature, we got a patent on it, would we even know? Most stuff is detectable given enough money. But then it comes a question of, so the detectability ranking really is, how much would we have to spend to figure out whether our competitors are doing something like this or not. Another business criteria is longevity. Is is this technology going to be obsolete in 5 years' time? Because if it is, it may really not be worthwhile filing a patent application on that. Geographic scope is another one. Is this a problem that is unique to Canada, or is this a global? Is it addressing a global problem? And so basically, what we'll do is take all of these, apply the legal and business criteria, and then kind of percolate to the top the ideas that we think are the strongest patent candidates, so that we're getting the best return on our dollar spent on pursuing patents. And that's where the timing and the costs come into it. Where if the startup has a certain budget, we'll say, okay, we've ranked all 80 ideas, and we have budget to proceed on these 10 or these 5 or whatever it is. And sometimes we can maybe even combine some of those ideas into if they're closely related. And as Garth mentioned, timing is also key. If the feature was released, and we're coming up on the 1-year anniversary of the feature being released, we might need to move on that, and may not have the leisure of doing a lot of thinking and evaluation of it. We need to get this thing filed as soon as possible. So basically, at this point, we may end up with a spreadsheet, 80 ideas. We've decided we want to action. So based on the ranking, then we'll action it. So Garth, I don't know, do you want to maybe talk about the next circle there, the action, the file, no file decision point?
Yeah, sure. I'd just like to add, just to mention the business criteria in deciding which applications to proceed with. Obviousness is, you've got, the hurdle must be novel, and invention must be non-obvious. If an invention is of high business value, then even if there are some concerns about novelty, about obviousness, I would still proceed to file. So, you're taking, it's a bit of more risky application that may not get issued, but it's of high business value. So I think business criteria and drive a lot of the decisions which Andre pointed out. So moving then, Andre, to your question, how many patent applications should we file, or should the startup file? I mean, in an ideal world, both a startup or multinational organization would file tens of patent applications for a particular technology area, but it doesn't work like that. There's no hard and fast rule. There's always budget constraints. So by doing the ranking, you identify what the most important assets are, and then you look at the budget and you see which ones you can address. And if there are other ways of maybe folding in certain inventions into other applications and subsequently mining them, but there's no hard and fast rule. I'd say a technique which we use quite frequently is when a startup is really budget constrained, is to file a comprehensive application that details many of the different components and inventive aspects that may be aware of. And then mining that application in due course with multiple continuation applications. So prior to one patent issuing, filing the continuation, claiming another aspect of the invention, and keep leapfrogging it. I've had situations where we've filed a comprehensive first application and got 10 patents issued off that. And obviously by leapfrogging it in this delay, we push out the costs as well, because your first application may take more cash to prepare and write, but it provides you a really solid foundation.
I've actually, just on that, you brought to mind, I was actually evaluating a patent portfolio for a client that they were looking at acquiring, and the target patent portfolio, basically, I think that startup had filed, I think maybe 5 or 6 patents, but they'd filed 2 very comprehensive provisional patent applications. And this was a few years later. They had spawned over 110 patents off just those 2 provisional applications. I mean, they were very beefy ones, but they had managed to, not saying that that would be common practice at all, but that was, to me, and that's the most extreme example I've seen, is really where this company took effectively 2 detailed provisional patent applications and 10 years later had over 110 patents issued off that. Anyway, just sorry I interrupted you there just to share that story. Yeah,
it sort of does tie in as well with our discussion on valuation and exit strategies earlier, and funding. What often happens, and we're digressing slightly now from this, is that we'll get called by the attorney for a company, a corporation that wants to acquire a startup, and ask us, well, what is the patent strategy? What have you guys done? And so by having a basic strategy and discussing it with the startup helps us to sell the startup to the acquirer. Typically, I would say, well, we filed this comprehensive initial application. We intend to mine it for multiple applications by way of continuations down the line. And we'll get to foreign filing if we have time afterwards. But I'll say, well, we've also filed a PCT application. We've reserved our rights in 130 plus countries, and we will in due course evaluate filing in those individual countries. If there's the spreadsheet, I can say, well, we tabulate all the new ideas that come in, that have been generated. We review them critically to see whether we should file them. We look at their business value. We look at whether they should be kept trade secrets. And so we can have a story to tell the investor or the acquirer that we don't look as if we just have this one application or two applications on file with no vision. So by meeting with a startup, discussing and understanding what their goals are, we can formulate a strategy for them, short-term, long-term, always dynamic, so that we can put the startup in a really good position from an IP perspective if ever they're looking for funding, or we get called by acquiring attorneys. So coming back to the Andre and I discussing, he spoke about that beefy provisional. An easy way to actually explain what we're talking about, because we're not sure exactly how much experience in patent drafting the audience has, but would be a bicycle. If our startup came to us and said, hey, we've developed a bicycle, it's got two wheels and a frame. If we just filed a patent application and the first document included two wheels and a frame, and the examiner came back and said, hey, that's obvious. There's a wheelbarrow. It's got one wheel and a frame. You're just adding another wheel. We can argue and not to get an allowance, but if we've also described the caliper brakes, we've described the gears, we've described the inflatable tires, the spokes, and all the components of the bicycle, we could then spawn off multiple continuation applications subsequently. And it's important to know that, or to bear in mind, that the components must be described in the first application to claim priority back to it. But we could spawn off multiple applications, one claiming the brakes independently, one claiming the spokes independently, the inflatable tires, etc., independently. And effectively, we could create a picket fence around a technology area that would make it very difficult for someone or any other entity not to infringe the startup's technology. They may leave the brakes off, but they would then infringe maybe the spokes, the patent on the spokes. And if we have a number of smart patents that effectively picket fence the technology, it makes it extremely difficult for a competitor to put a viable product on the market without infringing at least one of the patents. So that the strategy of the combination, to keep costs down initially, combining multiple aspects into a founding document, can pay off in the long run. I mean, ideally, you would want to file separate applications, but clearly budget doesn't always allow that. And at the time of filing, then the question becomes, well, should we be filing provisional applications? Should we be filing utility applications? And perhaps, Andre, you'd like to address that question. I see we have a question here quickly that's popped up. Maybe we can answer it before moving on. The question is, are organic patents more valuable than acquired patent assets? Do you want to address that, Andre?
Yeah, I mean, I'd say, and again, this is based on my experience, and I think it's going to depend heavily on the situation. But generally, we find that the organic patents or patent applications from a company tend to be a little more valuable than the acquired ones. But that said, I mean, you can get very valuable acquired patents. You just end up paying more. So to me, it's kind of a cost issue. an organic patent, and again, an organic patent is one, that's filed on technology that you may have developed within your company, but very often companies will go outside and acquire patents on the secondary market from other companies for various purposes. But if you are buying a very good patent on the open market, you may be paying $250 to $2 million for that patent, whereas the typical cost, kind of cradle to grave for a US patent is in the $30,000 to $60,000 range, and you're gonna have a hard time finding any valuable patent on the secondary market in that price range. So I don't think it's really probably compare organic, which are more valuable. It's just how much are you going to pay for those valuable patents, and an organic patent's probably going to cost you a lot less.
And there are situations where more sophisticated corporations would have a hybrid approach, where they acquire a valuable portfolio as well as having a very aggressive organic patent program. I've seen situations where a fairly mature startup had developed an internal organic portfolio, but were worried that they would be sued by a particular corporation. So what they did is they went out and acquired a portfolio that read onto, it wasn't an issue for them in protecting their product, but they were worried they could be sued. So what they did is they acquired a portfolio that read onto the corporation who they were worried about. So it was completely defensive, that if ever there was any litigation threatened, what they could do is sit down and start negotiating some license agreement. So I don't think initially I would say for a startup, it's going to be organic because it's just the cost factors, and it's probably more cost effective. But as companies mature, they do acquire patents where necessary.
And I'd maybe add there, and I think Garth brings up a good scenario where if the company wants to acquire patents for strategic reasons, vis-a-vis a third party, but that's where the value of patents can swing dramatically depending on what the market's doing. Maybe you've got a patent covering something that's hot now, but then someone comes up with an alternative, and the patent may go from a $2 million value to a $10,000 value very quickly, depending on what's happening in the marketplace, who's suing who. So there are a lot of market conditions which can actually determine the value of a patent, and those are continually in flux and varying. So always a little tricky to answer that question with a definitive answer. Yeah. Okay.
Andre, so maybe you can speak to, as I mentioned, the filing of a provisional application or full utility application. How, there are probably unique circumstances for each, and have your thoughts on that?
Yeah, no, sure. And again, often we're speaking to startups, and they'll say to us, "Oh, I've heard we can file these cheap things called a provisional patent application." Which is, should I be looking at that versus a full utility? And I normally say, I reserve kind of provisional patent applications primarily where we're under such a short time fuse that we don't really have much of an option. So occasionally we'll have a startup come to us and say, "Hey, we're announcing this product on Friday, and today is Wednesday." Clearly in that situation we're going to have to file a provisional patent application. But the reason a provisional patent application tends to be cheaper than a utility patent application is that it doesn't have the claims, which are the legal bit, which is quite frankly the main value out of your patent attorney, attached to the specification. And I always say, if you just take a technology description and you just file that at the patent office, it's a bit like building a house without a plan, because we're going to have to draft claims at some point. And if we just file that as is, we may be fine if everything we need to claim is described over there, but we may get to the point where we want to claim it and we figure out that we don't have a lot of the words we need to actually claim it properly. So it might be like building your house without a plan and discovering you kind of left the kitchen off. And so there's always that risk. But again, sometimes it is the only option. We will sometimes file a provisional patent application that has a specification that is in good form for a regular full utility patent application. In that scenario, the provisional patent application would cost as much as the utility patent application because we've done all the work. It's got the claims, it's got the full detailed description. But sometimes clients are wanting to file that. There may be an advantage where you want to, defer publication. Also, the 20-year clock on the life of a patent only starts running at the utility. So particularly if you're a drug company or a pharmaceutical company, having an extra year of life of your patent on the end, it becomes very valuable. So we'll see, chem, bio, life sciences companies often file the specification that could otherwise be filed as a utility patent as a provisional for that particular reason. Yeah, Garth, I don't know, any thoughts you had on the provisional versus utility question?
No, I think the important thing to note is that the requirements legally for a provisional application's written description are the same as for a full utility. It's basically the requirements exclude the claims and that's it. And the whole purpose of the detailed description and the drawings is to provide support for the claims. So it's really not an ideal way to proceed. I've also seen situations where, there's concern about competitors are maybe, advancing quickly in the technology space. And I think the drug companies do this, where they'll file multiple provisional applications and combine them into one single utility application within 12 months of the first filed provisional. So just to get information dump at the patent office and an early priority date, they'll file a provisional and try and make it as comprehensive as possible, obviously. 3 months later, may update or amplify that original provision to include further information and then subsequently file a full utility. But I've also found that many times over that startups have said, oh, no, we don't need to worry. We've got a provisional application on file. We're good. And no, you're not good. You're only good for, only as good as what's been described in that provisional application. So it does provide, in many cases, a false sense of security where it's been cobbled together quickly for whatever reasons. People believe, or the client believes, that they're adequately covered, yet they're not. So I think the general rule is provisional applications most definitely have their place, but one has got to be very cognizant of the risks that could arise from filing provisional applications.
Yeah, correct. Yeah, and again, I think another scenario to consider a provisional is where where your product is very, may not be very mature, and that there are going to be some big iterations. You may want to file, a provisional on the current version, but if in 3 months' time it's going to be substantially, move the ball down the development field, you may want to then, file a supplemental provisional there where you add the new stuff. And what we've done that is for some clients there, particularly if they want to get an early date in, and then, file a series of provisional patent applications and then kind of sweep those together into a single utility patent application is another strategy. But this all kind of comes in, I think when the patent attorney meets with the inventors and the startups and gathers all the information, can kind of normally come up with a suggestion about, taking the constraints of cost and time into account, what's going to be the best way to position the patent, or position things for success in the future. Garth, I see we're kind of at the end of the hour. I think patent strategy also has, there are questions about, do you file internationally, and what does it take to prepare a patent application? But I think we'd be happy to discuss that, offline if anyone had any questions. Garth, anything in closing?
No, I just, maybe in closing, I would say my experience has been having a patent strategy, and that can mean many different things, has in almost every situation I've been involved in, added value. The challenges are how to craft the best strategy and provide the best opportunities for patenting opportunities going forward on tight budgets. And we haven't gone into a lot of details on that, but there are definitely ways by limiting the initial costs, you can at least preserve some rights and have a path to protecting your technology in the long run. And so that's one thing I would say my takeaway has been over the years doing this job.
Excellent. Okay, well, with that, everyone, we'll conclude. Thanks so much for dialing in and attending. Hopefully you learned something. And yeah, do get onto our website, or you know, you can even email Michelle about the upcoming. As I said, we've got for the next. We're in the day where are we? Day 3 of our virtual seminar and our IP summit, and there's still a lot of good stuff to come. So hopefully you can join us for a few more sessions.
Yeah,
okay.
Thanks for taking the time to join us, folks.
Thanks, everyone. Okay.
Bye
Bye now.